Hello, and welcome to the Court AO Exchange Program's Knowledge Seminar. I'm your moderator, Charlie Hall. Of all the events that occur in a federal court, few are more central or more dramatic than a criminal trial. Today's Knowledge Seminar is going to provide an inside look at criminal trials from the viewpoint of judges, prosecutors, and defense lawyers. Today, you will witness a crime in progress, then follow the process from investigation and arrest through plea negotiations, through opening statements and witness testimony, and finally the jury verdict. I am pleased to introduce our panelists joining us today. To my immediate right is Senior Judge Henry Hudson. Judge Hudson has been a U.S. District Judge for the Eastern District of Virginia since 2002. In an extraordinarily rounded career, he has served as U.S. Attorney for the Eastern District. He has been U.S. Marshal for the entire federal system. And he even started actually as a deputy sheriff in Arlington County. He has truly seen the justice system from every possible angle. Moving further to the right, I'd like to introduce Magistrate Judge James Orenstein of the Eastern District of New York. Judge Orenstein has been an assistant U.S. attorney in New York. He also is an adjunct professor at the New York University School of Law, and he also has taught at Fordham and Brooklyn Law Schools. Also joining us is Zia Faruqui from the U.S. Attorney's Office in the District of Columbia. Zia has litigated numerous civil and criminal matters at both the District Court and Court of Appeals levels. His area of focus is on international money laundering in the areas of national security and cybercrime. And then finally, of course, there are two sides in every criminal trial. So representing the defense perspective is Kyana Givens. She's an assistant federal defender for the Western District of Washington, but Kyana currently is actually working here at the AO on temporary detail to the Defender Services Office. She's a faculty member at the National Criminal Defense College and for the Trial Skills Academy for Federal Defenders. She trains lawyers in the use of technology at sentencing and also addressing unconscious bias during jury selection. So welcome, Kyana, and thank you for being part of this. So now, if we could welcome our panel. Thank you. So to start our program, we have created a short video as an introduction to criminal trials. Let's take a look.
In federal court, the main prosecuting agency is the United States Attorney's Office. Often, the first stage of any case is an investigation where state or federal law enforcement officers gather evidence. Investigators must approach a judge in order to obtain a search warrant based on probable cause. In the federal courts, a magistrate judge often presides over these requests. If there's evidence of probable cause to believe that a person committed a felony, the prosecuting attorney may seek an indictment from a grand jury, formally charging the crime. The information or grand jury indictment provide the basis for requesting an arrest warrant from a judge. Law enforcement officers then arrest the suspect. During this stage, officers will give a Miranda warning to comply with the rights granted by the Fifth and Sixth Amendments. The suspect, now a defendant, is then brought before a magistrate judge without unnecessary delay for an initial appearance hearing. There, several things happen. A magistrate judge advises the defendant about the nature of the charges filed. Defendants unable to afford counsel are advised of their rights to a court-appointed attorney. If the prosecutor moves to detain the defendant pending trial, the court schedules a detention hearing. If the defendant pleads guilty, the judge may impose a sentence, but more commonly will schedule a later sentencing hearing. If the defendant pleads not guilty, the judge will schedule a trial. Before the trial begins, each district court randomly summons a jury pool of the defendant's peers. After the jury selection, the trial begins with opening statements from each side. Then the prosecution begins to present its main case. In a criminal trial, the burden of proof is on the government, and the defendant must be found guilty beyond a reasonable doubt. The sworn testimony of witnesses is the main way the prosecution presents the evidence of guilt. The defendant's attorney might cross-examine those witnesses to undermine the value of their testimony or their credibility. The prosecutor and the defense attorneys then present closing arguments. After the defendant's attorney's closing arguments, the prosecutor may make a rebuttal argument. After instructions from the judge, the jury then begins deliberation towards a verdict, which must be unanimous, guilty or not guilty. If their decision is not unanimous, the court declares a mistrial and the defendant may be tried again. If a jury finds the defendant not guilty, then the trial is over. The prosecuting attorney cannot appeal, and the defendant cannot be tried again in federal court for the same alleged offense, because the U.S. Constitution prohibits double jeopardy. If the jury finds the defendant guilty, the defendant may be taken into custody or released until the judge is able to hold a sentencing hearing, where he or she will determine the appropriate sentence. Felony sentences may result in large fines and a longer incarceration in a federal prison. Being accused of a crime is a serious matter, so verdicts and judgments require careful consideration, which takes time. The methodical approach to justice under the rule of law is a fundamental principle that binds our society together. It's a bedrock of our government and provides stability, security, and safety in nearly every part of our public and private lives.
Thank you to our video production team for that introductory video. We're going to switch to a different type of video. What you're about to witness is a crime in progress. In this bank video, 3 masked gunmen enter the bank, rob it, and then disappear. In the coming days, investigators will try to identify these gunmen. They also will name a 4th suspect who may be less obvious. As they say in the movies, today's knowledge seminar is based on a true story. Our questions will follow a scenario inspired by this real-life bank video, but with the help of our panelists, we've added some fictional wrinkles to help our discussion. So let's start with a very basic question. And as we see from the video, the suspects have masks and they get away. Judge Hudson, I would like to start with you. What are some ways investigators might start connecting the dots and begin identifying real suspects?
Well, taking it from the scene, Charlie, as you can imagine, there are a few calls that a police officer responds to that pose more danger than an armed bank robbery, not only to the officer, but also to the occupants. The last thing he or she wants is one of the occupants to be taken as a hostage. Once the bank is clear and it's safe for the officers to go in, the first thing they're going to do is do a quick protective sweep to make sure there's no danger left. Then they're going to begin collecting information. And one of their objectives is to identify as much information, clothing, characteristics of the bank robbers as they possibly can. Not only will the officers be doing that on the inside, but outside, police officers are going to be interviewing everyone in the area there they can find and stopping every car in the parking lot to get as much identifying information as possible to put out a lookout for that vehicle or those individuals. Often, even though their faces are covered, they have distinguishing characteristics such as tattoos, hair, distinctive clothing, or things like that. All that can help in identifying the perpetrators. They also want to notify the alarm camera company to get a technician out there to get the film so they can review that. And then they want the forensic technicians to go in and gather any fingerprints, hairs, fibers, or footprints that may be of forensic value.
Fabulous. Zia, as a prosecutor, how quickly are you brought into the investigation and what other things might be happening in these first couple of days?
We try to get involved as quickly as possible. It's interesting from having traveled and seen judicial systems in other countries, sometimes there's a real divorce between the prosecutors and law enforcement. But in our system, I think it works efficiently. Maybe sometimes defense counsel feel we're too close in arms. But we do try to be very involved from early on because ultimately investigators, what they're trying to do is collect evidence that can be admissible in court. And our job is to make sure that they are doing things in the legal fashion, collecting records. So for instance, if they're getting historical cell site location data, to see where maybe if they've identified a suspect where they're going. I know we'll talk a little bit about that. Supreme Court has recently ruled that we have to get that via search warrant. So they can't just call up AT&T and say, get me the last 6 months of this person's location information, because it may lead to the recovery of evidence, but if it's not admissible, to what end? And so we do try to get involved early on. Probably the biggest tool that we used is grand jury subpoenas. And so people are either compelled to come to our grand jury here in DC, or they can send records in lieu of appearance. And that's typically how we get information.
Judge Orenstein, I want to follow up on something Zia just said. Our scenario actually does involve some electronic information gathering. He mentioned cell towers. If you could tell us what a tower dump is, how it might play a role in it, and then how would you as a magistrate judge be involved once that began happening?
Sure. So our phones are always in communication with local cell towers so that if you get a call, you can be found. That generates a lot of information that law enforcement uses. And one of the big legal issues in recent years is how do the courts deal with that, and what kind of proof do prosecutors and agents need to show to get this information. So if you've got just the one robbery that we've got here, it might not come into play right away. But if you've got a pattern of robberies, someone like Zia will come to me and say, we want to get all of the information from the cell towers nearest each bank at the time surrounding the robbery. And the question is, do they have to show probable cause to get a warrant? Is it some lesser showing? That's actually still up in the air for that particular kind of request. But they'll come to me for permission to make the cell phone providers give them that information so that they can look for a phone that's in all three locations at the time of the robbery, because that'll help identify a suspect.
Okay, so Kyana, you have not been involved yet. You're a defense lawyer, not informed of this. During all of this kind of electronic gathering, specifically with connection with these cell tower dumps, which we'll use in our scenario, do you have any perspective as a defense attorney on this?
Well, this is the hardest part about being a defense attorney. Much like this discussion, we're invited late in the game. So there's been a lot of evidence gathering, and by the time I get involved is usually at the time where an arrest is made. As a federal public defender, we are appointed counsel, so we're assigned. And the way we do it in Western District of Washington is whatever comes through the door on the day that you're on duty becomes your case. And so if I was on duty this day and Mr. Bystander was arrested, then I would go for a pretrial hearing and represent him, and our primary goal would be release. The first step that usually I'm involved in is for a release hearing. And I don't think people know that we don't talk about the facts of the case and the cell tower dumps. It's really two questions. Is he going to flee, and is he a danger to the community? And if the answer is no to both those questions, then if I've done my job well, he gets to go home that night.
Okay. And so in our scenario, what's happening is that there have been multiple robberies with similar casts of characters. And in two of the robberies, these cell tower dumps show a single number that's come up, and that identifies a suspect. Judge Orenstein, my understanding is you've been involved in cases like this. In this particular case, we get the cell phone from the suspect. All the information is encrypted, so nobody knows who he's been talking to or what he's been writing. How do you handle that as a judge?
Well, it may not even come to me as a judge. There are a lot of ways law enforcement can try and get behind that encryption, including just seeing if they can work out an agreement with the suspect, to trade leniency to get access to his information, because it may lead them to others. But let's assume they can't. First step is they have to have a warrant to search the phone, and that's probably going to be the easy part. If they can show that the phone was at the vicinity of two bank robberies, I'm probably going to give them a warrant to do the search. But they try to do the search, and it's locked. They need a password or a fingerprint. And it's strange, but the law is actually different about whether you unlock a phone with a password or a fingerprint, what you have to prove to be able to get access to it. But what if you can't get the fingerprint or the access code? A lot of time what happens is law enforcement will come to me or someone like me and say, tell the company that made the phone, Apple, Samsung, whatever, to defeat its own security, force them to write new code, or break into the phone. And now you're recruiting a non-party to help the investigation. And that's an area that's really up in the air legally. The technology companies are opposing it. And I had one case a few years ago, but it's really unresolved about whether that can even be done legally. And if so, what's the authority? The government relies on a statute from 1789 for authority for this, and obviously something written then didn't have this situation clearly in mind. There's exactly one written opinion in the country so far on it. This is my opinion from 3 years ago, because often the government can avoid having to test it out legally, and it's in their interest to avoid doing that, to avoid getting bad law.
I've had the same experience that Judge Orenstein has had in cases where they want to get into encrypted phones. The service providers are going to resist every step of the way. I think they feel like they're compromising their relationship with their clients by not doing that, by being cooperative. Anyway, in each case that I have had, the FBI does have the capability of getting into those telephones, but as I've told a number of times, it is extremely expensive. Probably the people that can go into those telephones makes more than a brain surgeon does. It's a very, very complicated field, and there are few people that can do it. But there are other devices that are often used, Charlie, to track down bank robbers, and I'd be more than glad to add that if you wish.
Very quickly, sure.
All right, I had a case not long ago involving a bank robbery in Enrico County, Virginia. And they used a device that I have never seen before in 22 years in law enforcement. It is a 3SI GPS tracker. What is that? That is a device that is put in the bait bills, which are the bills that they give to the bank robbers to kind of activate the alarm system. With the GPS tracker inside 40 $20 bills, there is a tracking device that is in there. Once that tracking device is moved off the magnetic holder it sits on, it activates a satellite signal 15 seconds after it's removed. And within a matter of minutes, satellites pick up that tracking, and every 6 seconds it will give the longitude and latitude of that tracker and put it on a screen that the police dispatcher has. So he or she can route police cars directly to where that GPS tracker is. And in the bank robbery case I had, it took them about 4 minutes to track it down to a house about 5 blocks from the bank. So it's a miraculous device, and it really opens up a new vista when it comes to tracking down perpetrators of these types of crimes.
With the scenario, they get away. These phone records eventually start tying people together, and 3 alleged gunmen are arrested. But as I mentioned earlier, we have a 4th mystery suspect who's perhaps less obvious. The man in the blue jacket. Okay. The theory of the case is that, for reasons that Kyana will explain shortly, is he's not just an unlucky customer who's walked into the bank. That their theory of the government is he was here as essentially a lookout to alert the gunman if anything unexpected was happening. Now, Kyana, you are invited to the party. You have been appointed this man with the blue baseball cap to be your defendant. Tell us normally what you would do at this stage, and in this particular case, what have you learned about his circumstances?
Well, assuming that we're beyond the pretrial stage, but even as early as the pretrial release stage, I would be talking to him about his perspective. This is the government's perspective that he's a lookout, and I'm sure Mr. Blue Jacket's perspective is that he was in the wrong place at the wrong time. And so we would probably spend a lot of time talking about that. Eventually, I would, through my visits at the Bureau of Prisons, I would talk with him, and it is very likely to come out that he perhaps shared a cell with one of the people, perhaps the man who jumps over the counter on a prior offense. And still, my client's theory is that he knows them and he had presence, but he wasn't involved.
So Zia, I'm going to turn to you. With this lookout person, is this a case you would bring in real life, or would you want to do more investigating before taking him to trial?
I think it would be very challenging. I mean,
Yeah.
The best part I think about being a federal prosecutor, and I think the panelists here can speak to it even with more experience than me, but is being a gatekeeper. I mean, I don't want to charge cases that are where you're not sure. We have the luxury that we're in a business with a lot of supply, a lot of crime. So why would we go and pick the defendants or cases where we're uncomfortable or unsure? I think this one would be very challenging on these facts alone, if it's just someone that he knew were there. But you start getting more facts of, well, if they have shared phone numbers and shared phone calls, I think it is potentially a case that you would want to investigate more, not charge, but the goal. And I think that, I'm sure there's sometimes frustration that as prosecutors, we always want to try to toe the line of finding the people that will flip on the people above them, but not charging people that are so low down that it doesn't make sense in terms of resources. And that the only way you learn that fine line is, I think, through experience.
Judge Hudson, any thoughts?
Yeah, I agree. Having been both the state and federal prosecutor, state prosecutors are much more reactive. Ordinarily, by the time they get a hold of the case, the person's already in custody and getting ready for a preliminary hearing. And a federal prosecutor ordinarily has a chance to review it with the agents before there's an actual arrest, and it makes it much easier to handle.
Zia, you feel like you have enough information, and Judge Orenstein, you handle a lot of grand jury activity. What is the significance of taking a case to a grand jury for indictment?
Well, look, the process that Zia was talking about is a really important one in terms of prosecutorial discretion. Do I have enough to charge? And that's where the grand jury comes in. You use that subpoena power to get evidence before the grand jury. It's a group of 23 people who got jury summonses, only they got sent to one room instead of the trial court. And they're hearing just the law enforcement side of it, but they're seeing all of the evidence that might be available to support a finding of guilt. So the phone evidence, and maybe there's a cooperating witness who knows these guys and knows something about it. So they'll bring all that in front of the grand jury, and it's also sort of a sounding board for the prosecutor to see if this is a case that actually does appeal to regular folks. So there's investigation going on, there's a charging decision being made jointly with the grand jury, they have to vote on it, and that's how you get from that, do I have enough stage, to, yeah, this is somebody who should be going to trial.
Let me just add one thing, Charlie, if I could. Another advantage in presenting a witness before a federal grand jury is you can lock them into their testimony, and they can't retreat later during the trial. Particularly if you're conducting an investigation, and like I did a lot of white-collar type of investigations, and sometimes people want to weasel out of their testimony a little bit later when the trial comes up. They're locked in when you've taken their testimony in front of the grand jury, because there's a court reporter down that records everything.
Another really important aspect of it is it's completely secret. Somebody who's under investigation isn't having their reputation harmed just by being under investigation, but also, these investigations go step by step. And if it becomes public too early, the people who committed the crimes, if they become aware of it, can flee, they can destroy evidence. So the fact that it's kept secret allows the prosecutor to do an orderly investigation and present all of it at once to the grand jury for consideration.
Well, it can only be released by court order, is that correct? Yeah.
Okay, so in this case, the indictments are handed down. I think we eventually counted 5. We have the 3 gunmen, we have the alleged lookout person that Kyana is representing, and then, as Judge Hudson reminded, no robbery like this should ever be attempted without a getaway driver, so we also will have a getaway driver on trial too. There's a host of pretrial motions. Kyana, you talked a little bit about the bond hearing or the initial appearance. I'm thinking maybe Judges Orenstein and Hudson, you can walk us through some of the pretrial activity you guys have to face.
First of all, one of the motions that's made is a motion for discovery. The defense has the right to access to police reports, forensic laboratory examinations, some statements of witnesses, photographs, and things like that. One of the things that I have found when I was a prosecutor that helped resolve a lot of cases was to have an open file discovery policy. And I did that even when I was a state prosecutor in Arlington County, right across the bridge. Let them look at everything. There's never any debate later when it gets on appeal that something was withheld. Give them all the information, and most people will plead guilty if they have a strong case, if they see the evidence. Secondly, a motion to suppress. Often, a police officer seizes something without a warrant, or there's a search warrant that the defense feels is defective. It'll be the subject of a motion to suppress, to see whether that evidence can be used at trial. Often in a trial, prosecutors will want to use criminal conduct that happened at another time to show a common scheme or plan, motive, and things like that. That's what we call 404B evidence. And every time you use that, there's almost uniformly a motion to try to exclude that. And then you have motions to sever defendants when they claim that there's extreme prejudice because you're trying 2 or more defendants at the same time. Very, very difficult under the federal rules to have your client severed from the other members of a conspiracy.
If you take 100 clients who are convicted of a felony in the federal system, more than 97% will get there by pleading guilty. Fewer than 3% actually face a jury trial at all. Why do so few cases actually go to trial? Why do so many settle with a plea agreement?
some of it is based on the prosecutors. This is what Zia was talking about before, about choosing their cases. They're not going to choose the case that has some real weakness, which means that the defendant is going to feel less confident about going to trial. Sentencing guidelines and sentencing laws, including minimum sentences, give defendants a real disincentive to take a chance. Prosecutors have the discretion when a defendant says, no, I'm going to go to trial, to pile on more charges and to basically make it too dangerous, too risky to exercise your right to a trial. And on the other side, they can say, but if you don't make us take you to trial, we'll give you this really lenient plea. So a lot of it rests on the discretion that the prosecutors have to leverage their power and make it just too hard, too dangerous.
The U.S. Sentencing Guidelines, which is the guide that we use in sentencing, and we're required to put on the record that we have computed the guidelines and we have considered them and all the other statutory factors. They actually have a built-in incentive for people to enter a plea of guilty. You can get up to a 3-level reduction in your sentencing guidelines if you enter a plea of guilty. In addition, if you plead guilty and cooperate, even if you're charged with an offense that carries a mandatory minimum sentence, there are statutory provisions that allow the prosecutor to make a recommendation that you receive a below-guideline sentence. Also, in an indictment, you'll have some counts generally, not always, but sometimes, counts that carry a mandatory minimum sentence, significant mandatory minimum sentence, and others that don't. And it is sometimes an incentive for a defendant to enter a plea of guilty to every other count other than the mandatory minimum, because that gives them a lot more latitude at trial to argue for a more favorable sentence.
So if I may turn to counsel on both tables here, you're talking with each other about a possible plea negotiation. How does that work? What are you each looking for? How do you go about doing this?
So one of the things I think that's nice being in the U.S. Attorney's Office, different than my colleagues at Main Justice, is we get to typically appear before the same judges in our district, and we get to be typically working with, or against, however you want to say it, defense counsel. And so some of it is just having relationships that you built. There's certain defense lawyers that I know that start off with, just like when you're buying a house or something, a car. It's, if you don't know the person, you're going to try to start with a high offer and work your way down, or you can just say, look, this is the best offer that you're going to get. And so a lot of it is from repetition and getting to know and building up trust. I think more so from the defense counsel side. I mean, going back to what you were saying before of you don't know what's in that other file, right? And you don't know if there's a third file. And so it's the luxury on the prosecutor side that theoretically you have all the information in front of you, both weaknesses and not, and we have an ethical obligation to disclose those. But defense counsel's really got to, if they trust you, that's going to go a long way to making efficient plea negotiations, because they know that there's not something lurking out there that could make this a much more a challenging case, and that they really should be going to trial.
Yeah, I mean, I think plea negotiations from a defense attorney perspective is primarily a decision by the defendant. So it's not a choice I make, and it's not a choice that any of these folks get to make. I present the evidence, the facts, the law to my client, and they have a choice to make. And the reason why it's so important to have a well-funded public defense system is so that we have skilled people who know what questions to ask and know the risks and where we might be able to mitigate. So one of the things that Judge Hudson was alluding to was cooperation. But in all of these secret files, one of the things that I'm often doing is asking my client, is there any other information that they want to share? It could be nothing to do with this crime, but with some other unsolved crime. And maybe we can offer some information that is part of the negotiation to convince Zia to come down a little bit on his ask. But I also want to give the numbers. A bank robbery usually is nothing short of 5 years in prison. But so you're talking somewhere between 5 years, 20, 25 years. And so when Main Justice and AUSA say reasonable sentence, we're still talking about taking someone away from their families. And so that's where the high risk becomes a very big deal.
So in your case, we're talking potentially somebody might be adding on. The idea, I think, here is if somebody goes before a jury and they lose, they might be tacking on, any estimate, 10 years, 20 years to the sentence?
It could be as many as that or more. It could be, someone who I know in our office that there was a case where a person, they sought mandatory life, and in the federal system there is no probation where you get your 15% if it's less than life, and if it's life, then you're going to serve your whole life there. I think that judges, to some extent, they try to be the bulwark against that, but they don't want people to be punished for exercising their constitutional right to go to trial. That is a right. You shouldn't be punished for doing that. But by the same token, I think prosecutors are trying to weigh, you can't offer someone a better deal or the same deal necessarily if they go to trial, because there is, just like in anything else, you're trying to think about resources and other people that you might be investigating or prosecuting that crime. And so it's challenging. I think often what happens, for better or worse, is you look at what other people did before you and you try to measure up against that. Well, someone else had a similar bank robbery. How much jail time did they get if they went to trial from this particular judge? And how much time did we offer to cut off if we didn't go to trial?
And oftentimes, don't forget, I represent a person, and they're just like all of us who want something certain. So a common thing that happens in plea negotiations is Zia may say, hey, if he pleads now, I will allow you to ask as low as that 5-year, 60-month number, and I'll ask no more than 78 months. So it gives a little bit more certainty for the defendant to make a choice, and they may say, I'd rather go with something certain than the unknowns that could happen at trial.
So, Kyana, do your clients always plead, or do you oftentimes represent them in trial? And how would you handle this? What's your expectation in this case?
Well, in the federal system, there's no always. There's about nationally 1% of cases that go to trial. I know that I tend to go to trial a little bit above average because I don't mind dealing with uncertainty. And a lot of that has to do with the relationships I build with my client and the degree that I'm willing to go do investigation.
So in this case, your client has decided to go forward. Judges, any risks beyond the ones you mentioned already in that decision?
Well, one slight one, and this is really drawing on my basis as a prosecutor. Sometimes what you say in plea negotiations is, you plead guilty to this bank robbery, we're done. I've got other cases to move on to. But if I start preparing for trial, I'm really going to be investigating. You don't know what else I'm going to find out about your client, and there may be more charges, and so that is a risk of going to trial.
Following up on George Orenstein's comment, in almost every one of our plea agreements in the Eastern District of Virginia, there's a provision in there that the United States agrees not to prosecute the defendant for any other related nonviolent conduct. And that insulates them from just the thing that the judge was talking about a moment ago, and that is the trial revealing evidence that might support prosecution for other offenses. Now, I've had cases, I had one not long ago, where a defendant, after the trial, tried to suborn perjury by trying to have a witness go back and recant his testimony. And I understand he will be indicted very soon. But those kind of things do happen, and those are the risks you have when you go to trial.
So one last topic before we go to trial is selecting the jury. Judge Orenstein, why don't you tell us a little bit about the voir dire process?
Okay, well, and voir dire, it's not English, it's a Yiddish phrase meaning tell me about yourself. It's a process, people get their jury summonses, they come in, and usually, certainly in my district, in the federal system, the judge does the questioning, and in state courts it's often the lawyers doing the questioning. But the idea is to get information by, first of all, telling them what the case is about and asking them a lot of questions about their backgrounds, their views, maybe where they get their news from, to see if they have any biases that would keep them from being completely fair to both sides, given the kind of case this is. And the other purpose that the questioning serves is to let the lawyers make their decisions about who to excuse, because they have the right to excuse a certain number without giving any reason, as long as they're not acting on the basis of discrimination. They can just say, I don't like school teachers. I think they're bad jurors for this case. So, you're a school teacher, out. So it allows the parties to sort of figure out who's best for this case.
Zia, do you apply any particular strategy to jury selection?
Pick the best jurors? It's challenging. I think that it's. I had the opportunity to argue at an appellate court this exact issue of, struck a juror and there was a strike made. When we struck, the defense said that it was for, reasons of race and had to provide a race-neutral reason. And when it was in front of the circuit court, I generally like to be fairly familiar, I guess, to tell a little bit of jokes. And so I just told a narrative. I had just was gotten engaged to my wife, who is a PhD scientist, and I said that, if this juror was sitting the way that when I'm at the dinner table, my wife starts talking about very technical science materials, slumped over, kind of looking away, I said I would be sleeping on the couch. And I think that, those are things that are not like, you can't put your finger on it. It's a lot of intuition. It's an art, not a science. And you never really know what's going to happen. So I guess that's the closest I get to the position of having that kind of mystery file or the mystery what's out there. There's a total asymmetry of information. You may have a juror that you think, I recently had a trial, and with the foreperson was a corporate lawyer, and it was a kind of a technical case. We actually had a law enforcement agent we were prosecuting for smuggling money out and not filing those forms you get on the airplanes. And I thought, they'll definitely convict because it's so serious, and they convicted on one charge that we thought we wouldn't win, and they convicted on the other one, and we thought this juror was going to be great for the technical charge. And so this just goes to show you, I think that we probably, we're analytic people, and so I think we sometimes overthink. A lot of it is you just got to hope for the best and hope that you're going to get people fair. But I don't know, I think by and large, people are not coming up with wild excuses when they're faced with a federal judge asking the question, are you really someone who believes you can't put someone in prison? Are you really, most people back down and say, look, I'll be fair and honest. And I think that, they're in a community of their peers. You can't really have often people who are just kind of outlandish and doing wild things. So you kind of hope for the best.
So Kyana, how do you approach jury selection? And you mentioned that you study unconscious bias before. If you could weave that into your answer, that would be great.
Sure. So I think as a defense attorney, one of the things that we're trained to do is actually have a plan when it comes to selecting a jury. So if you get an opportunity to have what's called attorney-conducted voir dire versus judge-conducted voir dire, then it has to be consistent with your theme and theory of the case, your theory of innocence for your client. And so most defense attorneys, including myself, we go in with a plan, and we have some ideas of the types of jurors that we're looking at. But it's a misnomer to say you're selecting a jury. I think what we're moving toward, at least in my community, is we're deselecting a jury. We're plucking out the people who we don't think can contain their bias, or maybe this just isn't the case for them. Some people, there's just certain topics that there's no way, because we are all subject to unconscious bias. All of us in this room, out there, you can't leave that at the courthouse doors as much as you would like to. So as a defense attorney, we're more trying to get people to open up about where their biases lie. And I'll just say this, what the studies show is there's no voodoo to picking a jury. All you can do is sort of prime them to remember you're supposed to be unbiased, and by asking them questions about bias, you prime them to be more careful when it comes to making an ultimate decision. And that's about as good as we can get.
Judge Hudson, tell me a little bit about voir dire in your court.
Well, I have a standard series of questions that are very extensive. It probably takes me a half hour to 45 minutes to go through them with the jury. Before I even begin my voir dire, I always ask the defense attorneys in advance, 7 days in advance, to submit to me their proposed voir dire questions. So I integrate those in. I go through whether they are related in any way to the lawyers of the defendants. Have they ever met lawyers of the defendants? I go through the list of witnesses in the case. I go through the occupation, their occupation, the occupation, members of their family, whether they're members of the NRA, whether they're a member of any organization that is in favor of legalizing drugs in drug cases, whether or not that any of them are police officers. Whatever the nature of the case is, I try to find out whether anybody in their family might be in a position to have formed an opinion, and that could be contagious. It could affect them, and whether or not they've studied the law, or any member of their family is a lawyer, and whether or not they understand they got to set that aside and base their decision strictly on the law as I provide it.
A criminal trial begins with opening statements, first from the prosecutor and then the defense lawyer. So Zia and Kyana, in that order. Zia, tell us what kinds of things you try to focus on when you're doing an opening statement.
I think the thing you're trying to do is you're trying to tell a narrative, a story. There could be a very complicated fraud, Ponzi scheme investigation. It could be a bank robbery like this case, but whatever you're trying to do, you're trying to create a simple narrative, because folks haven't seen the video, right, and the jurors yet, and this is, the government is lucky to make the first impression, and so you both want to put out the narrative of what happens. But we always say that, in terms of strategy, you also want to take the sting out of anything that might be bad. So say, for instance, there's some fact that that's really going to look bad for one of your witnesses, or a fact that that really is in the benefit of the defense. You're going to take the earliest opportunity to get it out there so it looks like that the other side isn't getting that and that you weren't unprepared for it. You want, really, at the end of the day, the jury to think, look, this is our burden as the government, that we're prepared, we're organized, and that we're being fair and just laying the facts out without adding any color or showmanship and things like that.
Kyana.
Well, our strategy, I think, for opening statement is pretty much what Zia said, is to tell a story. As human beings, we're wired for story. So as defense attorneys, we pride ourselves in being the one that tells the best story, the best trailer for what the jury is about to see. We want them to be interested and watch out for things that we think are weaknesses in the government's case. And also, we may talk about things that we know will come out in the trial, and we never overpromise things that we aren't sure whether it'll come out, and if it does come out, whether it'll come out our way. So opening statements, I think, are important. I think you can have 50 defense attorneys in a room and they try it 50 different ways. So it's not a prescription, but it ultimately is about story, keeping the attention and telling them what they're about to see and why the government has it wrong.
So I want to actually turn to our two judges. And from this point on, Judge Orenstein is a magistrate judge, and magistrate judges do not try federal felonies. So we're going to draw now on your experience as a former federal prosecutor. But I'd welcome the thoughts from Judge Orenstein and Judge Hudson. What are the qualities of a strong opening statement?
Well, short, to the point, here's what we're going to prove and here's how. And establishing yourself, whether you're the prosecutor or defender, establishing yourself as the person the jurors can look to for the voice of reason. He's the voice of authority in the courtroom, but you're the person who's going to be, giving the honest broker of the facts, so that when things are in doubt, they'll look to your side and think you have some credibility.
I've always believed that opening statement, like final argument, is one of the greatest exercises of applied psychology you will ever have. And what it really is having a commonsensical approach to the evidence. It's the art of persuasion. In both a final argument as well as the opening statement, I think it's important to stress the main points in your case, but also give a commonsensical path of how they're going to reach the conclusion that's favorable to you. And that, I think, is the magic behind being a really effective litigator.
So I want to talk just briefly on the human side of this. Kyana, you have a real-life defendant sitting next to you who might be going away for a long time. What are they going through while this is happening?
Yeah, I always have a real-life defendant sitting next to me, and I think that's what makes me different. I'm dealing with people whose lives are really in crisis, and they're nervous and anxious oftentimes before trial. I make a point of the night before going to visit my clients because they're not going to sleep that night either. The family pressures are great. It's just riddled with anxiety. And part of my job is not only to be a persuasive and effective litigator, but it's also to counsel my client in a way that makes them feel confident that they're going to be treated with dignity and fairness and effectiveness.
And the human side for both you and Zia, you guys must be going through tremendous stresses for this moment of just having everything together for trial, standing before the jury. Do you go through any jitters or stage fright when this happens?
Go back to, I don't know if it's either very good or very bad to be married to a lawyer, but the one thing my wife knows is if there's a trial, it's just kind of, to stay away. It's not a good time, because you do get stressed out. You're working longer hours. You still have your regular docket, right? So, I can't imagine how many clients that you have. So you have to still go home at the evenings and pay attention to those other cases. And so it is a challenging time. You can't speak for anyone, but I find it hard to believe that most lawyers don't get a little nervous, no matter the most experienced ones, when you're standing up in front of a judge, let alone a jury. A jury is a total, you have an unknown. You don't know what you're getting into, and you're nervous because, it's your profession, you care about it, you want to do the right thing, and I think as a prosecutor, there are some cases where it's more obvious than others that there could be victims, or there could be a threat to the community, and you feel like if you mess up, that, someone could be hurt by what you hope is not a mistake that you make. So absolutely, it is you get nervous. But by the same token, after you get a few of them under your belt, once you start going, then it's like driving or anything else. I think you start to you just want to get into a rhythm and keep things going. That's why some people think an effective way to play defense or offense, whatever you want to call it, is to try to object and things like that. I think it's bad because I think jurors get annoyed because it breaks up their rhythm, and judges want things to be orderly. But some people think that's an effective way because it can throw the other person off from their rhythm sometimes.
So, Judge Hudson, you are in the position of having to manage the trial, starting with the jury, but then all the different motions, objections, and everything. What are the biggest things you have to factor in just running the trial?
Well, I want to keep it moving. I want to make sure that the evidence presented is competent evidence. I'm not going to be reversed on appeal. I want to be sure that I rule on the objections properly that come out. And while I don't always object on my own to things, if a lawyer is doing something that could lead to reversible error, I'm very, very quick to correct them, irrespective of whether or not a motion is made. I want to be sure that the jurors are treated properly and the time is not wasted during the course of the trial. And I want to make sure the jurors are properly instructed, and I want to be sure that all of the defendant's rights are properly attended to during the course of the trial. It's basically what I do in a kind of an overarching fashion.
So I want to come back. We mentioned the judge managing the trial, and earlier came up that lawyers also have to manage a lot of balls. Zia's mentioned a few. Kyana, do you want to talk about just a little bit of what other things you have to manage getting ready for trial?
Yes, I think it's important to say that I'm the defense attorney, but I don't do it alone. There's often, if I'm well-funded and supported, have an investigator, a paralegal, sometimes a social worker, also working with me. And often at the table, I'll have a paralegal with me as well. And so we're managing our team as well as the defendant, because remember, a defendant sometimes, like a bank robbery like this, may have sat through a week and a half of people saying things that he or she does not agree with. They have to bite their tongue. And so I have to prep them for what that feels like to hold their tongue, because they don't get to take the stand until the end. And sometimes just the anxiety of that and not being able to say, they got that wrong, or that's not, so we have to manage our client emotions as well.
So we're going to do one last question on the trial for the two lawyers, and then we'll start wrapping up the section. Zia and Kyana, tell us a little bit about how you organize your case, how you choose which witnesses, how you try to build it through evidence. And of course, Kyana, with your side, how do you decide whether to put your client on the stand or not? So Zia, if you could get us started with that.
Usually what we try to think of is the kind of the bookends, as you want to finish and off with a really strong witness, I think, who presents well. And you want to start with a witness who's going to set the table. And the in-between is where you're at risk of losing interest and things like that. And so those two are where, personally, where I would say I start with is who am I going to finish with and who am I going to start with, and then kind of work my way in the middle. You have I guess a natural inclination of wanting to do overwhelming shock and awe, put everything in, and that is not, I think, the best way to try a case. But I would say, again, everyone is different. You got to do the case the way that you feel natural and comfortable, because the jurors are looking for one thing. I think that's authenticity. And so if you have 4 witnesses that saw these people come in and you have the video, you do not need to put on 4 witnesses. That's going to annoy the jurors because they, we already heard that. Okay, move on, because they want to get back to their lives. I think it's going to annoy the judges because judges feel like it's their job to shepherd an efficient trial. And it's great for the defense lawyer because 4 people have seen 4 things that are identical, somewhat similar, but also differently. And so you're just putting yourself at real risk when you want to do that. So trying to get just the least amount of witnesses necessary to tell your story.
I think for me, any witness that I'm going to call has to be helpful to our case theory of innocence, and that's sort of the filter that I put every witness through. They have to be credible, believable, and relevant to the questions. Trials are actually, people think they're about a whole bunch of things. They're about the elements of robbery, really, and every witness has to add something to answering the questions about whether the elements of robbery are met. And if they're not, there's no reason for me to call them. Same by cross-examining witnesses of the government. I think it's hard for defense attorneys to learn that some of your best questioning is to know when to be quiet. As far as whether I put my defendant on the stand, I try to tell my clients that I don't work for them, I work with them. And they are as much a part of the team as all the other people that are on their team. And so it's a choice, again, much like whether they plea. Whether a person testifies at their trial is their choice. All I can do is prep them. But what I think I've learned over time is I tend to put my clients on the stand a little more often than maybe even my supervisor would like me to, because we're human, and people, jurors, want to hear my client's side of the story. And so if we can put him on and it's credible and relevant and there's some perspective that he or she can add that isn't there through the government's case, then absolutely I'll put them on.
Great, thanks. Yeah, please.
I agree with her completely. One of the biggest mistakes that I see in all the years, I tried over 100 jury trials, is asking a question, asking one question too many. When a lawyer gets a question, gets an answer to a question that is extremely helpful to their case, shut up and sit down. Because you might on that next question get the response, well, wait a minute, I want to clarify my answer to the last question. And that's particularly true on cross-examination. When you strike gold, sit down.
Good advice for future lawyers. We're going to go all the way down, beginning with Kyana and ending up with Judge Hudson. This is the moment of jury decision, or even everything leading up to jury, waiting for the jury to come back. Kyana, what's happening with you, your client, pretty much everybody? Just what is this like from the various perspectives you hold? And for you, Judge Orenstein, as a prosecutor, I think.
Yeah, I think waiting for a jury verdict to return is like waiting for a baby to be born. It is anxiety-riddled, but you're somewhat excited. If the trial went well, you're pleased with the work that you've done. But I can't ever forget that I represent a person. So it's not really about me and how I feel, but I have to remember to go to lockup. Usually my client, when we're waiting for a verdict, is in a lockup in the courthouse, and sometimes right behind the courtroom. And I get to go to my office, and usually I'm walking in circles because I can't eat, I can't do work. So I'll go over and I'll sit with my client, and we'll talk about what happened at the trial. I make a point to tell them what a pleasure it was to represent them, no matter what happens in the verdict, and I hear how they're feeling. So that's usually what's going on with me when I'm waiting for a verdict to return.
Zia?
I think there's a similar where a lot of pacing. You can kind of tell in the hallways when you know someone is waiting for a verdict to come back, because people are both avoiding the person but also trying to send positive thoughts to them. I think it's just stressful, and especially the moment we were waiting for the jury to read the verdict. It's an incredibly tense moment, and I think I hope that other people feel like, I was educated when I started in St. Louis by the U.S. Attorney's Office there, is that it's not like that we're high-fiving as prosecutors when it's over. If someone gets a 10-year sentence or a 20-year sentence, it's sad. Someone's life is, as Kyana's saying, they are taken away from their family, and that's not a good thing. There are people who are around that person that are going to suffer, and so you have to really, as a prosecutor, be ready to hear someone say not just not guilty, but ready to hear them say guilty, and know that you feel comfortable that the right thing is happening if that happens.
Yeah, and so as a litigator, I was mostly working as a prosecutor. It is a little different, and perhaps more like Kyana's experience as a prosecutor, when there's a victim in the case, which isn't very often in criminal trials. So then you're helping somebody get through that process a little more. But yeah, it's the most nerve-wracking time that you go through as a lawyer.
Well, for a judge, it's a little bit easier. I'm just sitting back in the office talking to my staff and waiting for a verdict and answering the questions of the jury as best as I possibly can. One of the most important things that we do is to make sure the jury has the support they need, copies of the exhibits, any other items they want to inspect, the guns and things like that. My bailiff handles all that. I just sit back on cruise control and wait until he comes in and tells me there's a verdict.
Although actually something was mentioned during the video, the notion of a potentially hung jury. Have you ever had juries that have struggled to get to a verdict?
I have, and what I do is I'll give them a modified Allen charge, which is kind of a statement to say that if you can't render a verdict in the case, your neighbor's going to have to come back next week and hear the same evidence and make the same decision. Hopefully that'll coax them into a decision.
Basically, I'd just like to ask, we've had a wonderfully full discussion. Thank you so much. I'd like to ask, starting with Kyana and moving towards Judge Hudson, What is one thing you would like people in this audience to take from today's discussion? And something I'm also curious about, we're talking about an adversary process with many rules that guide the introduction of evidence. As you talk about one thing you'd like us to take away, I'd welcome your thoughts on just generally how successful the process is at delivering justice. So, Kyana, start off with you.
I'll start with your last question first. I think it's difficult to measure how successful we are at delivering justice because still in our society we have a mass incarceration that has disproportionate representation of people of color in the system. And for all of us, that should be a concern. So if there's not an even sort of people who are in the system for various reasons, then I'm not sure we're reaching justice because we have too many, I think, black and brown people who are incarcerated and maybe not as well funded as they need to be on the defense side. One thing I would say, though, I love my job. I love being a public defender. I consider it an honor. We get to tell people stories. And I think Brian Stevenson says it best, that no one person is the sum of things that they did on their worst day. But I get to come in on their worst day and say, I'm with you. I'm aligning with you. I'm going to shoot for fairness. I'm going to negotiate on your behalf and try to get as close to justice as we can.
Yeah, if I ever commit a crime, I know I'm going to. I feel like Kyana, she sold me. She's a public defender, but if she had a business, I mean, I feel that's very moving. I think that the thing to think about is, I also, I love my job, and I think that I struggle maybe with some of those same issues of thinking about making sure, am I doing my job the right way and making sure that justice is being evenly doled out. I think the best thing about being a prosecutor is, at least in my experience in both St. Louis and DC, U.S. Attorney's offices, no one is measuring your success by how long of sentences and things you're doing. What they're measuring is, are you doing the right thing, and do you feel like you're doing the right thing? And I think there's very few jobs where you can go to where that's what you're being measured on, and that's why I think being a prosecutor, if you are doing it in the right place and have the right support, it's a really great and important job.
Do we always get to justice? Probably not, but we have a system filled with people who aren't in it for the money, that's for sure. They're doing it because they're trying to get it right, and that gets us a long way there. I'm not sure that you can measure justice by did we get the right result of guilty or not guilty. I think one of the things that we have to aim for is looking for other ways to deal with problems of crime by getting at their root causes. Courts can't really solve that, but they can try by getting away from these ideas of it's just about getting somebody to trial or to jail or declared innocent. We can be partners in trying to solve the problems that create the crime.
I can't look you in the eye and tell you that our criminal justice system is flawless, because it is not. But it is the best that I have seen. Until someone comes up with a better idea, I think we're well served by the system that we have.
I want to thank everybody on the panel. Unfortunately, we're out of time, so I want to thank those of you who asked questions and for joining us in today's knowledge seminar. And then for all of us here at the Administrative Office, I'm Charlie Hall. We look forward to seeing you at the next knowledge seminar.